take a look at legislative review in administrative law. Judicial review of public administration in the United States is episodic. It takes place in distinct cases. Individual judicial decisions eventually aggregate into the legal and constitutional doctrines that govern administrative practice. Legislative review is more continuous and diffuse. It takes place whenever a legislature is in session and deals with the entire range of administrative concerns: budgets, HR, implementation, organizational design, use of technology, strategic planning, policy choices, reporting, and even the architecture and location of agency buildings, offices, and other facilities. At the federal level, the constitutional basis for congressional review of administrative activity is crystal clear. The agencies implement legislative mandates with congressionally appropriated funds, often exercising delegated legislative authority. Therefore, Congress has a legitimate role in ensuring that agency actions are in keeping with legislative intent. It's well established that keeping a watchful eye on the administration of the laws it's enacted is an important function of our national legislature. The more difficult issue is for Congress to exercise oversight of agencies without undue micromanagement, causing needless inefficiency or interfering with principled administrative decision making. The following are the main mechanisms for congressional review of federal administration. The Legislative Reorganization Act of 1946 changed the standing committees in the House of Representatives and Senate with exercising continuous watchfulness of the administrative execution of the laws under their jurisdictions. In 1970, this language was strengthened to require the committees to review and study agency implementation on a continuing basis. This mandate is broad enough to support informal contacts between committee members and their staffs and agency personnel, as well as formal legislative hearings on administrative performance. Congressional review of administration relies on agency reports, often heavily. Congressional review is assisted by a number of legislative agencies. Congressional and state legislation is sometimes subject to sunset provisions. These specify that the programs or administrative operations that a law authorizes will terminate after a number of years, often 5, unless reauthorized. Sunsetting by Congress guards against the continuation of programs and agencies that have outlived their usefulness. It seeks to reverse the effect of legislative inertia by attracting specific consequences in inaction. Casework, or constitutionality service, is another means of congressional review, albeit a haphazard one. It runs the gaunt, from helping constituents arrange visits to Washington, D.C., to intervening in administrative processes to resolve problems with federal agencies. Through their staff, senators and representatives routinely send letters to the agencies on behalf of constituents. The agencies generally refer to these as congressionals and expedite attention to the matters involved.